Ein herzliches Willkommen an diesem schon recht winterlichen Dezembertag aus dem AußenwirtschaftsCenter London. Schön, dass Sie sich heute zum 4. und letzten Teil unserer Webinarserie Baustelle Brexit, jetzt wird es ernst, zugeschaltet haben. Mein Name ist Vera Meyer, ich bin die stellvertretende Wirtschaftsdelegierte hier am Außenwirtschaftscenter in London und ich werde Sie heute durch das Webinar begleiten. Nachdem wir uns in der Webinarreihe in den vergangenen Wochen bereits mit der allgemeinen Wirtschaftslage und den Änderungen bei Zoll und Steuern nach Brexit beschäftigt haben, an dieser Stelle ein herzliches Dankeschön an unsere Kooperationspartner vom Brexit Infopoint der Wirtschaftskammer Österreich, widmen wir uns heute dem Thema Brexit und Dienstleistungen. Freizügigkeit auf Sparflamme. Der Brexit bringt nämlich gerade für diesen Bereich wichtige Änderungen mit sich. Gemeinsam schauen wir uns an, worauf Sie zukünftig bei kurzfristigen und längerfristigen beruflichen Aufenthalten im Vereinigten Königreich achten müssen. Wir haben dafür eine internationale Expertenrunde für Sie zusammengestellt, die Sie über die wichtigsten Änderungen informiert und die Fragen aus der Praxis, die Ihnen unter den Nägeln brennen, mit Ihnen diskutiert. Was erwartet Sie in den nächsten 60 Minuten? Werfen wir gemeinsam einen Blick auf die Agenda. Im ersten Teil unseres heutigen Webinars geht es ums Vereinigte Königreich. Gemeinsam mit Rechts- und Steuerexperten diskutieren wir, was Sie in Zukunft bei Geschäftsreisen, bei der grenzüberschreitenden Dienstleistungserbringung und bei längerfristigen Entsendungen ins Vereinigte Königreich beachten müssen. Für diesen Teil des Webinars werden wir ins Englische wechseln. Im zweiten Teil, dann wieder auf Deutsch, widmen wir uns Österreich. Hier behandeln wir 3 Themengebiete, zu denen wir immer wieder Fragen gestellt bekommen. Geschäftsreisen und Entsendungen aus dem Vereinigten Königreich nach Österreich, die Situation für britische Saisonarbeitskräfte und die generelle Beschäftigung britischer Staatsbürger in Österreich ab dem 01.01.2021. Wie Sie sehen, wir haben ein dichtes Programm für Sie zusammengestellt. Dabei bleibt aber natürlich auch genügend Zeit für Ihre Fragen. Bevor wir jetzt aber in die Materie eintauchen, übergebe ich an Christian Kesberg, den österreichischen Wirtschaftsdelegierten hier in London, für einen kurzen und, wie ich ihn kenne, vor allem kurzweiligen Überblick zur aktuellen Situation rund um Brexit und die britische Wirtschaft. Christian, the floor is yours.
Herzlichen Dank, Vera. Für das ungefähr ein Drittel von Ihnen, die die Predigt des Wirtschaftsdelegierten schon bei unserer Auftaktveranstaltung oder bei unserem Steuerseminar gehört haben, sind die nächsten 4 Minuten eine exzellente Gelegenheit, sich anderen systemerhaltenden Verrichtungen zu widmen. Für alle anderen oder die mich unbedingt noch einmal hören wollen, lade ich zum wiederholten Mal jetzt zu einem Kurzbesuch am Krankenbett des britischen Patienten ein. Als Covid-19 auf Britannia fällt, trifft das Virus bereits auf einen wirtschaftlich massiv geschwächten Gegner und fällt auf fruchtbaren Boden. Großbritannien hat ein kaputtgespartes Gesundheitssystem mit vielen Vorerkrankten. Die hohe Bevölkerungsdichte und die massiven sozialen Ungleichgewichte begünstigen die Verbreitung der Pandemie. Und dazu kommen massive Fehlstellungen und Versäumnisse in der ersten Phase der Pandemie. Und es ist auch nicht gelungen, obwohl die Briten heute das erste westliche Land sind, das eine Impfung zulassen, bis heute nicht gelungen, das Land auf die zweite Pandemiewelle vorzubereiten. Die Briten bleiben Pandemie-Europameister mit einer Übersterblichkeit, die fast um das 8-fache höher ist als in Österreich. Das heißt auch, dass es wirtschaftlich hier viel steiler bergab und flacher nach oben geht als anderswo. Die britische Wirtschaftsleistung wird 2020 um fast 12% zurückgehen. Das wie vorgestern für Österreich minus 8% prognostiziert. Aber die schlimmen Nachrichten sind eher die, dass es lange brauchen wird, bis Großbritannien wieder in die wirtschaftliche Gewinnzone manövriert, vermutlich bis 2023 oder 2024. Dazu kommt das Damoklesschwert des unmittelbar bevorstehenden Brexit, des Abgangs aus der Europäischen Union. Das Spiel wurde auch bis heute gespielt, Souveränität versus Integrität des Binnenmarktes. Die Briten wollen Unabhängigkeit, die Union will robuste Garantien gegen den unlauteren Wettbewerb. Es ist mittlerweile ein sogenanntes Feiglingsspiel, ein Chicken Game in Echtzeit geworden, weil es gibt keine Verzögerungen. Es gibt am 1.1. passiert Brexit, wird Brexit Wirklichkeit. Meine persönliche Arbeitshypothese ist zunehmend, und das sind Entwicklungen der letzten Stunden und Tage, dass es tatsächlich am Ende zu einem Kuhhandel, 11:55 zu einem Kuhhandel kommen wird. Es wird mit hoher Wahrscheinlichkeit ein Freihandelsabkommen geben. Trotzdem, und das wird vielfach missverstanden, verlässt Großbritannien am 1. Jänner 2021 die Zollunion, den Binnenmarkt und das harmonisierte Umsatzsteuersystem, was zu einer Vielzahl von Schwierigkeiten und Problemstellungen für österreichische Unternehmen führt, die mit dem Markt Geschäfte machen. Das Geschäft mit Großbritannien wird schwieriger und es wird mit Sicherheit teurer. Und natürlich wird es auch in Zukunft durch die von den wirtschaftlichen Entwicklungen bedingten Nachfrageeinbrüche in Großbritannien erschwert. Trotzdem bleibt es profitabel und es wird keineswegs unmöglich. Großbritannien bleibt die zweitgrößte Volkswirtschaft Europas. Großbritannien bleibt ein Nahmarkt, fast ohne Kultur- und Sprachbarrieren, ein Land mit niedriger Unternehmensbesteuerung, mit unternehmerfreundlichen Rahmenbedingungen, ein spannender Spielplatz für Technologieunternehmen, eine Plattform. Die Briten sind in Hightech-Bereichen wie Artificial Intelligence, Cyber Security und vielen anderen IT-Segmenten nach wie vor Ranglistenführer. Es bleibt eine spannende Plattform für die Internationalisierung von österreichischen Startups und für ihre Finanzierung. Es bleibt ein Sprungbrett und eine Brücke für das Geschäft, das internationale Geschäft im Commonwealth, aber auch in anderen internationalen Märkten, wo die Briten viel stärkere und tiefere Netzwerke haben als wir. Und es gibt natürlich zusätzliche Geschäftschancen durch massive Investitionen, die der volkswirtschaftlichen Entwicklung gegensteuern sollen. Im Infrastrukturbereich denken Sie an Straßen, an Schiene, an Schulen, an den Bildungssektor, an Maßnahmen der Regionalförderung, aber auch an eine sehr ambitionierte Klima- und Energiepolitik, die Geschäftschancen auch für österreichische Unternehmen schafft. Dem britischen Markt eine kalte Schulter zu zeigen, wäre ökonomisch mittel- und langfristig eine dumme Idee. Brexit wird Wirklichkeit. Bereiten Sie sich vor. Ich appelliere an dieser Stelle an Sie, unsere Informationsangebote zu nützen, damit Sie die begrenzten Beratungskapazitäten in Wien, an den Landeskammern und hier in London nicht in eine Triage-Situation manövrieren. Wir sind knapp an der Grenze dessen, was wir bewältigen können. Wir würden uns gerne mit Detail- und Verständnisfragen auseinandersetzen, auf die Sie sich vorbereitet haben, indem Sie das, was wir ins Netz gestellt haben, nützen und aufarbeiten. Brexit wird Wirklichkeit. Let's get it done. Ich bin überzeugt, dass es sich wirtschaftlich zumindest mittel- und langfristig nach ein paar Monaten voller Kopfweh für uns alle lohnen wird. Vielen, vielen Dank fürs Zuhören. Ein ganz besonders herzliches Danke an die noch einmal zugehört haben. Und zurück zu dir, Vera. Und ich wünsche Ihnen eine so möglichst vergnügliche Veranstaltung, soweit das im Rahmen dieser Bedingungen überhaupt denkbar ist. Danke.
Herzlichen Dank, Christian, für die wie immer interessante Einführung in die Thematik. Ich glaube, das ist eine gute Basis für das, was wir jetzt besprechen wollen. Und deinen Appell, sich vorzubereiten, dem schließe ich mich an. Dafür sind wir heute da und ich möchte daher gleich unsere britische Expertenrunde einladen zu uns. This is also the moment for me to switch over to English, as our panel consists of international experts today. Let me introduce them briefly. Today with us are the lawyers Kaylee Whiter and Mike Tremere from Flatgate LLP in London. Kelly is a partner in the immigration team and advises, amongst others, on immigration and citizenship. And Mike is a partner in the employment and labor team. And his expertise lies in a wide range of employment matters, including disciplinary issues, termination, discrimination, and others. So hello to both of you. And we have also Alex Altman with us today. He completes our panel. He is a partner at Blick Rothenberg in London. He is a tax expert, a dual qualified accountant in the UK and Germany, and he specializes in UK and European VAT, as well as cross-border tax disputes. Hi, Alex.
Good afternoon, Vera.
Quite some knowledge that we have assembled around the virtual table. Let's put it to good use. And I suggest we jump straight into our first business case. We will start with an easy one. What should EU citizens consider when taking business trips to the UK from the 1st of January? Kelly, would you please start with the immigration perspective?
Thank you, Vera, and good afternoon, everyone. It's a pleasure to be with you today. In terms of business trips, there's two main considerations that companies need to think about. One is the length of the trip to the UK. These should generally be short trips, certainly of no more than 6 months in duration at any one time. And secondly, they've got to consider the activities that the individual employee is going to be carrying out in the UK. These need to be permitted activities. And what I've set out in the slides here, you'll see are some of the most common permitted activities for business visitors in the UK. They're self-explanatory, so I'm not going to take you through them in detail. But providing an individual is coming to undertake some of these activities, it should be fine to do so as a business visitor, and no visa will be required. They simply need to arrive at border and they'll be entered as visitors. There are sometimes specific circumstances where it would otherwise constitute work, such as in the sort of manufacturing and supply of goods. There's specific provisions within the visitor rules for those individuals, though. So depending upon the particular circumstances, they may find themselves covered within the business visitor rules. With prohibited activities, which is sort of on the other side of the coin, and this is where you have to really consider, is it a business trip or would it require a work visa? I've set out what the Home Office define as prohibited activities, but you'll note it's not a very clear explanation. And unfortunately, the Home Office have never given a very detailed explanation as to what constitutes work in the UK. But a general rule of thumb that we operate under is if an individual is coming to the UK and will be effectively undertaking their normal day-to-day role, whether that is at an office, at a client site, or some other location in the UK, then that is not going to fall within the business visitor rules and will likely require a work visa. So just to recap, the main considerations: assess as early as possible. Try to plan your business trips in advance as far as it's possible to do so. Consider the length of the trip, consider the purpose, and if in doubt, consult.
That is, I think, a very wise last word that you just said. If in doubt, consult. I would like to consult with you on one thing. I had a peek at your slides and something jumped out at me. And it says that a manufacturer can supply goods and install them in the UK. There are many cases where it might not be the manufacturer of a good to supply or even to install it in the UK. Might be somebody who has been contracted for installation, or maybe a manufacturer that buys part of the product that he would like to install, just manufactures a part of it. What's the case here?
So it's a really good question, and it's a very grey area, and the visitor rules have always been like that, unfortunately. And this is one where we are actually consulting with the Home Office to hopefully get some clarity on, because I can see it coming up more and more. Because if you read what I've written there is actually the definition under the rules and the guidance, and it does specifically say an employee of a foreign manufacturer. So effectively, it's expecting that the individual is going to be installing the equipment that's been manufactured by their own company. It could, when you look at prohibited activities, you can see at the bottom there, providing goods and services, but it refers back to unless it's one of the permitted activities. So this is where the grey area comes in. If you are effectively an intermediary and you have purchased you've got a contract with a UK company, but you've purchased the goods from another business and you're just going to install them or service or repair them, you may trip into work as opposed to permitted activities. So it's certainly something we're looking to consult with the Home Office on to see if there is any scope within permitted activities to allow for this scenario.
Okay, so it's wait and see in this case for us.
Yes, unfortunately.
Yes, but let's move on to Mike and the employment law perspective. What's your take on it, Mike?
Yeah, so I've interpreted this business trips as being a relatively short trip to the UK for a defined purpose, perhaps a meeting, perhaps a short-term consultation with clients or customers. And the truth is that if that's the case, there's unlikely to be many legal issues to worry about on the employment and labour front, because it's very unlikely that individuals visiting for just a short period of time will establish any statutory rights or anything like that here in the UK. So I think we'd probably be thinking more on the practical side. for these sort of trips on the employment front. And you might want to put some sort of details in writing with the employee for some basic details of their trip, essentially, the purpose for it, who they are to come and visit, and what is the purpose, and who they'll be meeting with whilst they're here. And the other practical matter I thought that it might be worth considering and raising if needs be is just reconfirming the content of any expenses policy. So how is the employee to travel to the UK? What class of travel are they entitled to? If they do have to stay for a period, will they receive some living expenses, and what sort of accommodation can they stay in? But I think largely for this sort of visit, it's likely to be practical matters like that which are going to be more concerning than technical legal issues as to statutory rights and entitlements here in the UK.
A very short, very concise answer. Quite understandable though, as this is not your prime area now. But let's move on to Alex and the tax perspective. Is there something we need to take into consideration?
Yes, thank you very much, Vera. From a taxation point of view, I have some good news and bad news. The good news is that Brexit does not change the income tax rules or the payroll tax rules. And this is because income taxes and payroll taxes are not harmonized across the European Union and are therefore not subject to change. Cross-border taxation issues are dealt with by double tax treaties on a bilateral level, as you know. So between the UK and Austria, in our example, we will continue to follow exactly the same rules. And that's the good news. The bad news is that this does unfortunately not apply to social security rules, which are subject to EU-wide simplifications, as you may know, which potentially won't apply anymore from next year, or only in a very limited way. One very important simplification for social security is a fixed secondment. Social security contributions can continue to be paid in a home country where the employer is based, and not in a country where the employee is working at, which is an advantage to maintain social security entitlements once the employee returns home. This procedure can work for up to 2 years, but will potentially change from next year. Unfortunately, we don't know the exact details yet, if this is reduced to 1 year, but we expect that a trade deal will clarify this point. In our first case here, a short-term business trip from Austria to the UK, social security should not be an issue anyway, since the business traveler is not seconded to the UK, but remains on the Austrian payroll. But the question is whether the business traveler might have to pay UK tax on his or her work days in the UK. The general rule is that there is no payroll obligation in the UK just because an individual visits the UK. There must be some deeper connection of the business traveler with the UK for taxes to apply here. For example, the traveler exceeds a certain number of work days in the UK, or a traveler actually works for a UK entity during his or her visit. If an employee works for someone in the UK, for example, a UK entity of the Austrian group, the UK entity must usually have some degree of control or management of that person that comes to the UK. So in other words, tell them they need to do certain tasks in the UK on certain dates, etc., etc. If this is the case, then we say that such a business traveler might be economically employed in the UK and might be subject to UK payroll taxes. If a traveler is economically employed in the UK, we then usually look at different time categories, how long a person stays and works in the UK. And the slide is showing 4 different rules here. I don't want to go into much detail now. However, the important points to consider are, don't rely on the 183-day rule in the tax treaty. The employee could be subject to UK taxes much earlier, even from day 1 in the UK, if they are economically employed in the UK. If this all does not apply, then yes, the 183-day rule can apply.
Okay. Quite something to take in, not too much of a change so far. Nevertheless, I would like to bring up the first question that we got from our audience, and it was actually the very first question that was put into the chat, which was, how is the A1 certificate? How is this going to play out? Until now, I'm a business traveler. I was supposed to carry an A1 certificate, our viewer wrote. Is that still necessary from January 1st, or how shall I do it from now on?
Yes, so as I mentioned earlier, the final agreement on social security operation has not been finalized yet. We expect that with a trade deal. We do not have final confirmation if an A1 certificate will continue to be valid in the UK. My understanding is that the Austrian authorities are currently still providing A1 certificates, even for secondments to the UK in 2021. And I would certainly go ahead and still apply for these certificates now. The only question really is, will the social security contributions in the home country on secondments continue for 12 or 24 months? This is basically a landing zone where I expect us to be next year.
All right, thank you very much. Let's conclude this first business case. Let's conclude the first round. It was only the warm-up. Let's go on to business case number 2, when we talk about cross-border activities. So that means installation work, maintenance work, IT support, consultancy services, all services that are provided cross-border. Kelly, what's your aspects to consider from an immigration point of view?
Okay. So again, we're back to this, certainly from the installation service repair type function, we're back again to this permitted activities under the business visitor rule, such as for the employees of foreign manufacturers. They will still be in a position whereby they can come as visitors for up to 6 months at a time, not beyond that. Beyond that would require a work visa. But interesting when you mention IT, consultancy services, etc., that will very much depend if it falls into the foreign manufacturer role, whereby, you know, you are a company who has manufactured the goods and you will be dealing with the servicing, etc. But if you are simply an IT consultancy company who is sending IT consultants to the UK to work at client sites, etc., that's going to be work. That is not going to fall within sort of the general permitted activities as a visitor. One of the important things is when we've been talking about permitted activities and visitors and the amount of time you can spend in the UK, we know that visitors are entered for up to 6 months. However, the Home Office do actually set out some guidance, especially under this employee of a foreign manufacturer rule, where they talk about the activities, the time being spent in the UK being relatively short. And their guidance actually suggests less than a month. But we know obviously there are circumstances whereby someone would need to spend longer than that. It doesn't mean that you wouldn't be allowed to come in for longer than that period of time. It just means you might be further scrutinised on entry. Having said that, we do use the e-gates in the UK for Europeans and certain other nationalities. So there is a lower chance of the sort of a border officer pulling you to one side and really examining your circumstances. But again, what we would be saying to sort of employers is arm your staff with, you know, the documentation they will need to prove the necessity for them to be coming in under this category, so that if they are pulled aside at border, they can, you know, whether it's a letter from the company or whatever explaining what they're here for, how long, that it is under contract, etc., all of these things. Ultimately, if it falls outside of, again, this very specific definition of permitted cross-border activities, a work visa is going to be required, which is going to need to be obtained prior to entry to the UK. So again, it's back to that point of planning your trips, planning out your projects in as far as in advance as you possibly can.
Let me follow up on this point specifically. Yeah. So we have this 6-month duration. That is the maximum amount that is allowed for business visitors. We now have companies that have longer term engagements, some of them a couple of months, some of them even 1 or 2 years when they are installing or at a construction site, for example, where they need specific people on a continuous basis because they can't just swap them out. So what's the possibility for them? I mean, 6 months and then they have to go back. Can they come straight back, or is it for 1 year, or do they have to bring in other people? It would be just good to have some clarity.
Yeah, there's different options here in this circumstance. Obviously, because an individual can't be for more than 6 months in any one period, like one go, if you like, in the UK. An obvious one would be to rotate the skill set, rotate the individuals every 6 months if it's longer term. However, if you need a specific individual and that is going to be longer than 6 months, then you might actually have to consider, is it better to get a work visa for them, and then you're not restricted on the time they spend in the UK? Because although technically there is no rule that says, you know, you can spend a maximum period of 6 months in any 12 months in the UK, there is the provision that you mustn't be effectively living in the UK through successive visits. So if someone does 6 months, leaves, and then re-enters quite soon thereafter, whilst again, because of e-gates, they may go through and there be no issue, but likewise, they could be pulled aside, and the Home Office border control officer could turn around and say, actually, I don't think you're here as a genuine business visitor, and really you should have a work visa. So it's something that would need to be assessed on a sort of individual basis to work out what is the better option. I mean, one thing I'll throw in there, Vera, I mean, it's not on my slides, but if some of these staff that you will be sending have already entered the UK and maybe done a day's work or something, it's, you know, before the 31st of December, and sort of, so really within 2020, we have the concept of what's called a frontier worker. And there is going to be a frontier worker permit introduced from the 10th of December, which for those who not sure if their activities are really going to go beyond permitted activities of visitors, or might be a bit longer than 6 months, not quite sure, if they've already done at least 1 day's work in the UK before the end of this year, they could apply for a frontier worker permit. And the concept of a frontier worker permit is, I'm an individual who has some employment in the UK. Doesn't mean it needs to be an employment contract in the UK, but some employment in the UK, but I primarily reside overseas. So as long as generally on a rolling basis, you're not spending more than half the year in the UK, you could benefit from that. So that's something we're exploring with companies as might be a good alternative option, possibly.
Thank you very much for sharing that with us. So December 10 to look forward to, and then for a lot of companies, it might be back to the drawing board to rearrange or see. Well, let's move on to Mike once again, also to bring in the employment law aspects.
Yeah, so this seems to me that it's something of a more formal work arrangement here in the UK. In my mind, it probably still doesn't quite constitute the sort of work where there's going to be a risk of individuals necessarily acquiring employment rights and protections in the UK, because the cases indicate that that will apply where there is a sufficiently close connection to the UK to justify those employment rights and protections. And in some cases, the UK is the territory or the jurisdiction with which the employment is most closely connected. And what I'm taking, that might well be the case for somebody who's been here for a reasonably long period, 6 months, if they've got short length of service previously in Austria. But I'm seeing this more of a situation where you have an established employee in Austria who is going to be coming to the UK for a more sustained period of work under the business trip, but still would consider their home and their employment to be in Austria, and would still consider there to be a more close connection to Austria than would be the case here in the UK. And so assuming that that is right, still technically we're not really getting into much of a risk area here in the UK. You might look to treat the arrangements a little bit more formally than you would the shorter term business trips. You might put some more formal documentation in place again, some sort of a letter to the employee to confirm again the purpose of their visit and how long it's expected to last, where they're going to be working from, what sort of hours they're expected to work. You might even, if you're talking about a visit for some months, need to think about practicalities like holiday, and whether people would want to be able to take holiday during this period, whether it would work for them to be able to take holiday during this period. Something where I think you might become a little bit more concerned about, and clients or visitors that they're coming to work with might become more concerned about for a more prolonged, perhaps more involved type of work arrangement like this, is thinking about confidential information and intellectual property. If they're going to be having access to third-party confidential information, Both parties presumably might want to consider putting some sort of wording or some sort of documentation in place to protect that confidential information, to prevent it being revealed to competitors, being used if the employment should terminate. And similarly, intellectual property, if they're going to be here for a sustained period, for example, doing IT work or software development work, you would want to think about who owns the intellectual property that they create when they're here, and how that would work, because the starting position in the UK is that any intellectual property created by employees in the UK will automatically belong to the employer. But there might be some complications where there are several employers or several parties involved, and it isn't entirely clear who it is that's meant to own that intellectual property. So I think we're certainly getting into the territory where we need to be thinking more seriously about arrangements and putting documentation in place, but perhaps still not in the territory where people would be acquiring unfair dismissal protection, rights to UK statutory protections and benefits just yet.
Just to follow up very briefly, aren't there situations where English employment law would be applicable, such as construction sites where I have minimum wage requirements, etc.?
Well, so yes, I think most likely if employees are working here in the UK, they would be entitled to certain base minimums that may be covered already under legislations in place, posted worker directives and things like that. I would expect or I'd anticipate that most people coming over would be certainly above those national minimum wage thresholds that we have here in the UK. An interesting point might be living wages. I mean, London living wages and living wages like that, which aren't strictly speaking legislative requirements. It might be worth considering and thinking about, and you might need to think about what arrangements you have in place with your suppliers and contractors to make sure you're complying with obligations on that front.
All right.
But again, I don't think it necessarily requires a deep dive on that front. It's certainly worth considering those sort of minimum protections, and if there's any risk that we're not meeting them, it's worth considering and thinking about in more detail.
Just to bring it up, that there are some aspects or some situations where we should dig definitely deeper. I agree. Well, moving on as time is pressing to Alex and the tax perspective.
Yes, so taxation follows the same rules as for a business traveler in this case, very similar to the case before. For tax purposes, it depends how long the employee works in the UK and if they are economically employed by a UK-based company, which exercises some level of management and control of the employee. So, for example, the Austrian group has a UK subsidiary which is involved in providing the installation contract, and the Austrian worker works on a work schedule provided by that UK entity. That's the tax view, basically. For Social Security, we would treat this as a secondment. 12 or 24 months, as I mentioned before, no clarity yet. Contributions can still be paid in the home country. I would still recommend to apply for an A1 certificate with the Austrian authorities now. I would also want to highlight some other taxation issues for installation projects in the UK. For example, a potential VAT obligation for the Austrian company providing some installation work in the UK. Customs rules might also apply if the Austrian company brings in certain building materials to the UK from the 1st of January 2021. CIS obligations, if the seconded Austrian employee works in the capacity as a subcontractor for another UK-based contractor, there might be some CIS obligations in the UK. And finally, there might be a permanent establishment risk if the building contract exceeds the 12-month period as provided by the double tax treaty between the UK and Austria. A permanent establishment for corporation tax purposes might be created as well. That would be my view on these tax issues, Vera.
It is, I know, quite a short time to put this all in, and I can see by the questions that are coming in that they're very detailed at the moment. So we will pass them on to Alex, or we'll try to deal with them and help you out on these. I would like to pick one out that I think we can deal with at this spot, at this moment, and it is about the VAT, British VAT versus Austrian VAT, especially for consultancy services. Can you just briefly comment, when is British VAT applying? When is Austrian VAT applying? Is there a guideline that you can give us, or would that be too much for this forum?
Yeah, I can very quickly summarize it. If we are looking at a B2B supply, a business-to-business supply, then the general rule applies in this scenario, which means VAT should be charged from where the service is provided. And if the work is provided from Austria, because this is where the main consultancy or IT work takes place, then the Austrian company should apply the reverse charge if the customer in the UK is a business. So no Austrian VAT charged, because the customer on the other side is accounting for UK VAT under the reverse charge mechanism. If the seconded Austrian employee creates a presence for VAT purposes in the UK, which means the consultancy services are actually provided by that employee in the UK to a UK customer, then UK VAT could apply. Then the Austrian entity might have to apply for UK VAT and then charge UK VAT to the customer. In a B2C scenario, business to consumer scenario, no VAT would apply if the consultancy service is provided from Austria to the UK-based consumer, because for B2C services, only telecommunication services are currently covered by the UK VAT arrangement. Any other services from a B2C perspective from the 1st of January is outside the scope of EU VAT and also UK VAT.
Thank you very much. This was very concise, actually. Thank you for the summary. I would like to move on to business case number 3, and I think it's one where we see the biggest changes. We're talking about secondments, so längerfristige Entsendungen of Austrian employees to UK subsidiaries. And Kelly, the burden of explaining the looming changes rests on your knowledgeable shoulders now.
Thank you for that one. So basically, we are looking at a new immigration system coming into force from the 1st of January. And obviously, it has been widened in its scope to prepare for the fact that European nationals will now fall within the new immigration system going forward. And when we are looking at secondments of individuals from overseas companies into the UK, we're firmly getting into work territory, meaning visas are going to be required. So this is now, again, we're talking about new arrivals to the UK from 1st of January onwards. And if they're coming to work, they will require immigration permission before they travel, which means that sponsors are going to be required. UK companies will require sponsor licenses. And it may be a situation where they've never had to do this before. Possibly, we may even have overseas companies who do not have yet a UK presence. So it's one of those situations where if they don't yet have a UK entity, they're going to need one so that they can get the sponsor license, so that they can sponsor these individuals. So there's quite a lot to be done there. In other situations, people may already have the UK presence, but they've not got a sponsor license, in which case we're urging people to do so as soon as possible, because there is going to be a flood of applications expected in early next year. And for those that maybe already have their licenses, just make sure they're up to date, that they need renewing. Possibly do you need to apply for more what we call certificates of sponsorship to enable you to bring the staff you need over going forward. Now, generally speaking, there will be 3 categories of work visa under which companies will bring people to the UK. 2 of them sit into what we call the intra-company transfer route, and one of them is called the skilled worker route. Typically, intra-company transfer has always been about an employee of an overseas business who's part of what we call the sponsor group, who is sending someone to their UK entity for a short-term assignment. The skilled worker route is more considered for new hires to the UK business, or even for longer-term assignments. However, you will find that it does have advantages over the intercompany transfer route, which I'll go into in a little bit more detail. Intercompany transfer route, there's two. There's the general intercompany transfer route, and then there's the graduate trainee. Intercompany transfer as a general route is for those who've already been working for the overseas company for at least 12 months prior to application. It also has minimum skills thresholds, which is actually set quite high. It's at the level that we had just before the 1st of December, which is graduate level roles. Now, not every person being transferred will meet that skills threshold. So it's a case of looking at the particular role and matching it to what we have as codes of practice in the UK on a skills level basis. Again, skilled worker route may be more beneficial here because it has a lower skills threshold. It's not to say someone must be a graduate, it's just the role must be at that level. There's also minimum salary requirements for intercompany transfers, 41,500 gross annual salary. The intention is it's a short-term assignment. It does not lead to settlement in the UK. And there's a maximum time period that an individual can spend in the UK, 5 years out of any 6, if you're sort of earning that 41,500 or so, or it can be 9 in any 10 years if you're what we call a high earner. So you're earning over about 73,900. The other route is the graduate trainee. That is when someone's coming as part of a structured graduate training program, and there is a maximum length of time you can be in the UK. It is very firmly 1 year and no more. Like with the general intercompany transfer route, you do have to, it has to be a skills role to graduate level, and the individual in this case only needs to have been working for the group for 3 months prior to coming. Moving that down into the skilled worker route, the reason, as I've sort of alluded to before, that it may be preferential, even where you would ordinarily send someone down that intercompany transfer route because they work for you already, is because the skills level is lower. The skills threshold, if you want to call it, is lower on the skilled worker route. We don't have a resident labour market test anymore, so that's great. There's no need to advertise to the local labour market. The annual salary requirement is actually lower as well. It's set at 25,600 gross per annum, or the going rate for the job. Now, again, this is about what we call SOC codes, which are codes of practice that identify each and every role and have a minimum salary threshold against it. So if a job, for example, requires has a minimum salary requirement of more than 25,600, you would have to pay that minimum salary level. But if the minimum salary level is below the 25,600, you would have to pay the minimum 25,600. There's no maximum length of stay in the UK, so it's quite flexible for employers. And it does ultimately lead to settlement, which may not be the intention in this scenario, but it's just there as an option. The main difference is the English language requirement as opposed to the intercompany transfer. So an individual would either need to hold a degree that was taught in English or sit an approved English language test. But from our perspective, as immigration advisors, often we find, depending on the role and the salary, it may actually be beneficial to bring people under the skilled worker route, even if intercompany transfer might have been the original intention.
Thank you very much. This is definitely something the companies will have to have a good look at, and will come back with questions. Kelly is very happy to help you. We are as well, if there is anything you would know in particular. In terms of timing, I have to move on to Mike to ask him for his input on the employment laws perspective, please.
Yeah, so we're now getting into a much more substantive secondment and work period in the UK, I would think. And so this is the sort of territory where I would expect to see some quite detailed paperwork to reflect that. And typically you'd expect a secondment agreement between the Austrian entity and the UK entity. And within that, you would set out how the arrangement is going to work in practice, how day-to-day management and supervision of the employee is going to work. You would also expect to see a secondment agreement between the Austrian entity and the employee themselves to kind of confirm similar details. Some of the areas we'll need to consider in those two documents are set out on the slide here. One is control and management. So I think Alex alluded to in one of his tax points, there is a control is quite a significant point, both on the tax test front and also the employment test front, as to whether somebody is an employee here in the UK and so entitled to UK protections and benefits or not. And so the more control that the host, the UK host, has over an individual who's coming to work here, the more likely it is that they will start to acquire some UK benefits and rights. And so you will want to have some language in these two documents and some agreement between the three parties as to how management and supervision is going to work. And typically what I would expect to see is that day-to-day management and supervision of employees may pass from the employer, the Austrian employer, to the UK host, but that overall management and control you would try to keep in the Austrian entity. So annual appraisals, salary reviews and things like that, you would expect the employer, the Austrian employer, to continue dealing with rather than the UK host. And that might be the case, of course, if it's just a 6-month secondment, but actually what's quite common is these secondments last for quite a long period. And even if they started being envisaged just for quite a short period, it's not unusual to see them having been continued over many years. And so these sort of things start to become relevant. We would also need to consider things like holiday and sick leave. I mean, in theory, holiday at least is driven by European legislation, and so there should be broadly comparable holiday entitlements in both Austria and the UK. We have an entitlement to 5.6 weeks, 28 days for full-time workers here in the UK, and so you would need to consider if that is more generous than what they would be entitled to in Austria, how that's going to be addressed. Whether they are entitled to the 28 days will still depend on the circumstances, I'm afraid. The classic lawyers get out, but if they are here for a sustained period and there is clearly control and they have sufficiently close connection here to the UK, it's possible that they could accrue those UK entitlements. Again, we'd want to think about confidential information, I would think, intellectual property, and perhaps in a more sustained arrangement like this, post-termination restrictions. The host, the UK host, might expect some sort of protection against the employee leaving the Austrian employer's employment and being able to compete with them, use their confidential information. And I'm sure there's some commercial arrangements that need to be considered between the host and the employer as well around payments that could be made to the employee. Typically, again, the Austrian employer would continue to make those salary payments, but might charge the costs to the UK host if the UK host is having the benefit of the employee's work. I should say, just to make it clear, that as far as we know on the employment front, not a lot is going to change on the 1st of January. I mean, all of the commentary and noises around Brexit and employment protections are that nothing significant is going to change very quickly. And certainly we haven't seen any legislation or proposals for changes. So none of this, I'm afraid, is particularly affected by Brexit yet, at least, but that may well change, of course, in the coming months and years.
We will make sure that when we have major changes to invite you back to have definitely more information. But Alex, may I ask you for your very brief answer on the tax perspective on this?
Yes, sure. So first point I want to raise is that, as it was mentioned, historically, a secondment could be structured in two different ways. Most common secondment was that the employee stayed employed with the Austrian employer on the Austrian payroll, was seconded to work in the UK. In this case, the same tax rules would apply again. So 183 days rule or economic employment issue, which might lead to a tax obligation much earlier. The other way of structuring a secondment is to send the Austrian employee to the UK and employ them with the UK subsidiary, as it was mentioned by Kelly and by Mike. Which automatically and immediately creates a payroll obligation in the UK. With these changes of the immigration rules coming in on the 1st of January, as explained by Kelly, my understanding is that the first structure, so keeping the employee employed by the Austrian entity, might be quite challenging going forward, and the second structure will probably become the most common one. As I've shown on the slides, this will mean a payroll obligation in the UK, usually from day one. I should also mention that the Austrian employee can access various tax reliefs in the UK in the first 2 years at least, like the detached duty relief, which allows for a deduction of various travel and accommodation expenses, similar to the doppelte Haushaltsführung in Austria, which is an important planning point for secondment, since the employer can potentially reimburse such expenses as a tax-free benefit in kind. If the second structure is chosen, so the secondee is employed by the UK entity, then UK social security contributions must also be paid from day one, as well as workplace pension contributions.
All right, thank you very much, Alex. And I have to say, our time is up, unfortunately. So it's a big thank you to all three of you. You have shed some light onto the changes that are ahead or onto these topics in general, and they will definitely keep us and our Austrian companies on their toes for a while longer. So goodbye to all three of you. Thank you for joining us.
Thank you.
Thank you.
And we will be swiftly moving on to our German part. Und ich wechsle wieder retour ins Deutsche. Ich darf unsere vierte Expertin zu mir auf die virtuelle Bühne bitten. Das ist Natascha Gulam, eine liebe und sehr geschätzte Kollegin aus der Wirtschaftskammer Österreich, aus der Abteilung für Sozialpolitik und Gesundheit. Und sie beschäftigt sich besonders mit der Thematik Aufenthalt und Beschäftigung britischer Staatsbürger in Österreich nach Brexit. Dazu heute eine kurze Zusammenfassung, vor allem zu diesen 3 Punkten. Natascha, wir freuen uns auf deinen Beitrag.
Ja, vielen lieben Dank. Ich freue mich, da zu sein und Ihnen die österreichische Sicht auf die Dinge darzulegen. Wir haben uns die 3 Kernfelder ausgesucht: Geschäftsreisen und Entsendungen nach Österreich, Saisonniers und längerfristiger Aufenthalt und Beschäftigung von britischen Staatsangehörigen in Österreich. Und zwar bei Geschäftsreisen kann ich Sie schon gleich beruhigen. Also da müssen Sie sich keine Gedanken machen, wenn Sie eine Geschäftsreise für Vertragsverhandlungen, für Vertragsabschlüsse vornehmen. Solange sich das in einen 90-tägigen visumfreien Aufenthalt befasst, ist das alles absolut unproblematisch und genauso wie bisher gehabt möglich. Bei längeren Entsendungen sieht die Sache schon ein bisschen anders aus. Also bei Entsendungen für zum Beispiel Montage, für Werkverträge oder für Arbeitsaufträge müssen Sie sich als Arbeitgeber mit 2 Dingen befassen, nämlich mit dem Aufenthalt, mit der Beschäftigung. Beim Aufenthalt müssen Sie sich, wenn der Aufenthalt nur 90 Tage beträgt, dann brauchen Sie sich um kein Visum zu kümmern. Darüber hinausgehen müssen Sie aber schon ein Visum beantragen für die nächsten 90 Tage. Und sollte der Aufenthalt noch länger andauern, dann müssen Sie eine Aufenthaltsbewilligung einholen. Im Konkreten muss da der Arbeitnehmer eben eine Aufenthaltsbewilligung oder ein Visum bei der österreichischen Vertretungsbehörde im Ausland, also zum Beispiel in London, beantragen. Anders sieht es aus bei der Beschäftigung. Auch hier müssen Sie sich damit befassen, wie lange die Person beschäftigt werden muss in Österreich. Bis zu 4 Monaten genügt eine Entsenderbewilligung. Darüber hinausgehend brauchen Sie eine Beschäftigungsbewilligung. Beides können Sie als Arbeitgeber bei der regionalen Geschäftsstelle des AMS in Österreich beantragen. Bei Saisonniers sieht die Sache schon ein wenig anders aus. Entscheidend ist hier der Jahreswechsel. Also wenn wir hier zum Beispiel eine Skilehrerin haben aus Großbritannien, die noch dieses Jahr im Dezember 2020 nach Österreich kommt, brauchen Sie sich nicht den Kopf zerbrechen, sondern der Aufenthalt und die Beschäftigung laufen genauso wie bisher gehabt. Absolut unproblematisch und ohne jegliche Komplikationen möglich. Sollte es ein behördliches Nachfragen geben, dann reicht es, wenn Sie eingeben, dass die Arbeitskraft schon 2020 nach Österreich gekommen ist. Denn das heißt, dass diese Arbeitskraft eben bis zum Ende der Saison jedenfalls rechtmäßig auffällig ist und jedenfalls beschäftigt werden kann, ohne weitere zusätzliche Anforderungen. Anders sieht das leider aus bei Saisonniers, die erst nach dem Jahreswechsel nach Österreich kommen. Also wenn wir zum Beispiel eine Skilehrerin haben, die erst im Oktober 2021 kommt, für die Saison 2021, 2022, heißt das leider, dass sie dann genauso zu behandeln ist wie jede andere Drittstaatsangehörige. Heißt, dass beim Aufenthalt ich mir je nach Aufenthaltsdauer, also 90 Tage, entweder kein Visum brauche oder ein Visum beschaffen muss. Und bei der Beschäftigung muss der Arbeitgeber eine Beschäftigungsbewilligung im Rahmen der Kontingentverordnung einholen, und zwar beim AMS, bei der regionalen Geschäftsstelle. Der Jahreswechsel ist auch entscheidend für den längerfristigen Aufenthalt und die Beschäftigung von britischen Staatsangehörigen in Österreich. Wenn zum Beispiel britische Staatsangehörige schon dieses Jahr nach Österreich kommen, also jedenfalls vor Jahreswechsel, zum Beispiel es kommt eine Britin im November 2020 nach Österreich und möchte hier länger da bleiben, dann hat sie die Chance, dass sie ihre Aufenthaltsrechte bisher sichert und ihren unbeschränkten Arbeitsmarktzugang sichert. Wie geht das? Sie hat die Möglichkeit, einen Aufenthaltstitel nach Artikel 50 EUV zu beantragen. Achtung, das ist nur nächstes Jahr möglich, also nur zwischen dem 01.01.2021 bis zum 31. Dezember 2021. Und das ist auch nur in Österreich möglich bei den für Niederlassung und Aufenthaltsrecht zuständigen Behörden. Das kann Landeshauptmann, Landeshauptfrau, Bürgermeister, Bürgermeisterin, Magistrat in Wien oder die Bezirkshauptmannschaft sein. Für all jene, die nach dem Jahreswechsel erst kommen, sieht es leider sehr schlecht aus. Also die sind dann gänzlich als Drittstaatsangehörige zu bezeichnen, mit all den Komplikationen, die das nach sich zieht. Heißt eben, dass sie einen Aufenthaltstitel für Drittstaatsangehörige ansuchen müssen, nämlich eine Rot-Weiß-Rot-Karte zum Beispiel oder einen anderen Aufenthaltstitel. Zudem ist eine Beschäftigungsbewilligung zwingend erforderlich. Das war jetzt ein ganz kleiner und ganz kurzer Überblick über den Aufenthalt und die Beschäftigung von britischen Staatsbürgern nach 2021. Aber wenn Sie eine detailliertere Auskunft wollen oder eine Detailfrage haben oder eine Ausnahmeregelung haben, finden Sie weitere Informationen auf unserer WKO-Brexit-Seite, die stetig aktualisiert wird. Gute Informationen bekommen Sie auch auf www.migration.gv.at und zwar zum Aufenthalt und zur Beschäftigung von Drittstaatsangehörigen. Auch beim Bundeskanzleramt sind Sie ganz gut aufgehoben und zwar bei der Brexit-Hotline. Sollte sich Ihre Frage trotzdem nicht beantworten lassen, freuen wir uns auf eine Mail unter brexit@wko.at. Ja, und ich danke Ihnen für Ihre Aufmerksamkeit und ich gebe ab an Vera. Vielen Dank.
Vielen Dank, Natascha, für diesen kurzen, aber sehr intensiven Einblick. Wir haben hier auch die E-Mail-Adresse von der Sozialpolitik eingeblendet. Falls Sie Fragen zu diesem Thema haben, einfach dorthin wenden. Es wird Ihnen geholfen. An dich, wie gesagt, Natascha, ein herzliches Dankeschön noch einmal. Auch von dir möchte ich mich jetzt verabschieden. Wir sind nämlich am Ende angelangt. Am Ende unseres heutigen Webinars, aber auch am Ende der Webinare Baustelle Brexit, jetzt wird es ernst. Die 3 vorangegangenen Webinare gibt es noch zum Nachschauen auf unserem YouTube-Kanal. Ich habe sie Ihnen hier aufgelistet, falls das eine oder andere noch interessant ist. Aber auch darüber hinaus sind wir selbstverständlich weiter für Sie da und stehen mit Rat und Tat zur Seite. Der Christian Käsberg hat es eingangs schon erwähnt. Wie Sie sich vorstellen können, werden wir aktuell von sehr vielen Unternehmen mit Fragen beschäftigt, gut beschäftigt sogar. Und das bringt uns schon langsam an unsere Beratungskapazitäten, an die Grenzen davon. Ich möchte Sie daher an dieser Stelle noch einmal auf unser umfassendes Infoangebot hinweisen, das wir auf unseren Webseiten publizieren. Und zwar finden Sie das unter wko.at/außenwirtschaft/GB und auch unter wko.at/Brexit. Beide Seiten habe ich hier für Sie aufgelistet. Diese werden laufend von uns aktualisiert und sind die beste Quelle, um sich über die neuen Entwicklungen zu informieren. Wenn sich daraus Verständnis oder Detailfragen ergeben, auch gerne persönlich an uns. Sie können sich ans Außenwirtschaftscenter in London wenden, am besten mit Fragen mit Bezug zum Vereinigten Königreich. Und es gibt den Brexit-Info-Point in der Wirtschaftskammer Österreich, der am besten mit Fragen zum Binnenmarkt und mit Österreich-Bezug kontaktiert wird. Wir können Ihre Probleme zwar nicht immer lösen, aber wir können dabei helfen, die Unklarheiten zu beseitigen, die es gibt. Und dazu passt auch, was ich Ihnen zum Abschied noch typisch britisch mit auf den Weg geben möchte. Keep calm and get ready. Now's the time. Denn jetzt wird es ernst mit der Baustelle Brexit. Vielen Dank und liebe Grüße aus London.